everybody. Welcome back to another episode of The Hard Truth. Thank you so much for watching. I want to talk a little bit about the hearings and what Bethany may know. All right, so grab that nice cup of coffee, a nice cup of tea as we begin our story.
Everything else along all the notes is what there is, and it's been provided to the defense. And if they're hoping that there's something else there, it's not there.
Prosecutor Thompson got a little spicy here talking about the DNA evidence, but the truth of the matter is there is one lab report about the DNA that's missing. And so the defense is not just digging for whatever they can find. They don't have everything. My question is, will the defense be able to bring the DNA evidence in to expose the corruption in the investigation? I understand the prosecution doesn't want the DNA evidence brought in, but can the defense bring it in? And people might say, why on earth would the defense want to bring in the DNA evidence so that the jurors can hear that they found his DNA at the scene?
It's a fair question. Let's do this. Let's put a pin in it. Boop, pin in. There you go. Now, let's let that hang there a bit, and then we'll address that when we thought things through, okay? Good enough, everybody? Smiles all around? Let's get out of here.
Judge doled down on the trial beginning on October the 2nd instead of granting the defense's request for a pause because of the grand jury indictment. Well, I think Judge did Brian a favor because if you don't take the speedy trial option, the state can drag you like a piece of meat. The trial could be put off and put off and put off. He can be sitting in jail for years just waiting for trial if he doesn't go for speedy trial. And so there's a lot of people saying, well, the burden of proof is on the prosecution. He doesn't have to do anything. The state has to prove its case. Well, while the state is proving its case, he's still in jail. Okay, he didn't get a bond, and he's not going to get one. So, I mean, this is his life. Who's going to sit in jail for 2 or 3 years waiting for a trial? I mean, if he doesn't make it to a speedy trial, I feel the prosecution will intentionally drag him, okay, and just really take all of his hope, between now and say a year from now. He may be up and at him and ready to fight, but a year from now, still sitting in that jail, becoming complicit with some of the things that are going on in there. I mean, times change, people change, situations change, attitudes change, stamina runs. This is an overview of the right to a speedy trial according to American law. All right, and the Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Okay, here it talks about undue delays. The Constitution protects against undue delay in criminal prosecution through a series of component measures rather than through one overarching requirement of timely prosecution. And that's a mouthful, but I think Judge is, going along with this, protecting against undue delays. All right? The serial Constitution protections, in turn, are supplemented by statutory protections. First, the Due Process Clause provides a basic safeguard against extreme government delay in bringing criminal charges against a suspect. So here it's talking about how long the government can take to try somebody. All right? And so they don't want the defendant They have to sit there in jail. They can't get a bond while, you know, he might be innocent. But the flip side of that is the defense asking for a pause when they have the speedy trial, right? I mean, if you need more time, you can't give that up, because if you give that up, Brian Kohlberger is going to be in there so long waiting for a trial, people will forget about him. The next big, you know, how do you say it, sensational case will come up. And I mean, people will only even pay attention to the case if some big news about it comes up. All it takes is for another tragedy on the same scale or with higher intensity, you know, a bigger offense against human nature and human rights. That's all it takes for everybody to say, well, Brian Kohlberg is stuck in jail, honey. He missed the speedy trial. They weren't ready. They needed more time. And so they just let it float by, and he's going to be sitting in there for a long time. So let's find something else, you know, juicy or more interesting to watch. Now, this is just my opinion. My opinion. If Bethany Funk has exculpatory evidence that could clear Brian Kohlberger, then they need to get this trial on the road. She refused to come back and testify at a preliminary hearing, and then she was supposed to meet with Ann Taylor and give a statement or answer some questions. But the bottom line is she needs to be on record saying these things. And so they need to want to get this trial, you know, get the show on the road, because that's the only way he's going to get some help for himself. Taking time to fight the grand jury indictment, I think, could be counterproductive. A time waster. All right, these people are obsessed with making Brian Kohlberger the culprit. He doesn't have a bond, and they didn't even want a preliminary hearing. Okay, so to me, I just think the trial is his way out. The trial is his opportunity to plead his case and to bring things in that we never would have heard about in the media, especially if it's to his benefit. The only way we'll hear about it and be able to weigh it, you know, and form opinions about it is at trial. And so, in my opinion, I think the grand jury indictment, to challenge it, is great, but to ask for a pause in the proceedings when you got speedy trial date coming up October the 2nd, I think the focus should be on Bethany, whatever she's got, getting these and getting the facts out in court in a way that the prosecution has to be held accountable for the things that they have told us that are not true. I think this is the way, the direction they should be going, to have him exonerated. All right, I could be wrong, and so let's look one more time at the document where they're stating that the exculpatory evidence and everything will come out at trial. Okay, I can't put my finger on it yet, but there is something that's not right in it. Let's read this last paragraph of the defense's answer to the demand for the alibi. It says, Mr. Kohlberger's defense team continues investigating and preparing his case. Evidence corroborating Mr. Kohlberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state, as well as calling expert witnesses. Now, we know that the expert witnesses will come in and attack the phone ping evidence and the claims of knowing where Brian Kohlberger was moving around between, I guess, 3 and 5. All right, so we know that's the expert witnesses, okay? That's what they're going to come in to do. And that shouldn't be too hard because we already know that the cell tower radius extends beyond where Brian Koberger lives. Even though he lived in another city, he lived close enough to the crime scene to where you could really say it's all in the same city. I mean, if you lived in Atlanta and somebody lived 8 miles away, I mean, that's the same city. So we have to think about that. The second thing is the cross-examination of witnesses produced by the state. What state witness can provide information that will alibi Brian Koberger? Especially if there's no connection between Brian Koberger and any of the roommates. This is where I'm stumped. If there's no connection between him and Bethany, why are they subpoenaing her for information? Or to, check what she told police. What did she tell police? Because they won't even tell us. They told us what Dylan said, but the PCA only mentions that Bethany talked about what time everybody got home. So there's something wrong here. There's something wrong with Dylan's story being missing from the PCA. There's something wrong with the defense wanting to subpoena Bethany, even though we don't have her statement. There's something wrong with Brian Koberger's alibi being based on the testimony of the state's witnesses instead of witnesses that the defense calls for their own client. There's a lot wrong here. And so we need to talk about it. All right? Let's go.